Ready to proceed?
No, we're asking for a continuance, and let me tell you why. First off, I've just been appointed, and second of all, I'm not appointed, hired. And, he has a case, tomorrow in Uvalde on a forgery of financial instrument that he was indicted in, and the arraignment is tomorrow.
Oh, they're not gonna take him from here until this case is resolved. Like, they're not gonna transport him until this is resolved.
So what's gonna happen to the arraignment?
Oh, I have no idea. But they're not doing anything there until this is resolved.
Well, I think we still need a continuance so that we can see what we need to do to work out both.
All right, have you conferred with the state on this? Yes. All right, so I require that everybody confer.
Oh,
Okay, all right, thank you.
well, I don't know, what do you think we're going to see?
Oh, you just,
What are they gonna say? Yes, no,
State.
whatever?
Yes.
can you speak to him on Jesse Gonzalez? It's on page 9. All right, thank you. Thank you, you're welcome.
See, there you go. Have a seat. Second chair.
All right, anyone else ready?
Yes, that's page 3, first one. For Yvonne Watson. That's the one I'm supposed to log in on.
They're not on.
No, okay.
Okay, who's next?
That's all I have for now. Today.
All right. Okay, that's fine.
Sorry, Judge, I had them confused. It's the other way around.
Oh, what? All right. All right, Jesse Gonzalez.
I'm sorry.
I'm sorry,
I'm
yes.
not used to the,
Oh, that's okay.
I've known this kid his whole life. I've known his father, his whole family.
All right, so my
Fine.
understanding, it's okay. So my understanding on the motion to revoke, it's just failure to report.
Correct, Judge.
All right, so we'll set it for contested.
Yes, it's not true. Yes,
All right.
thank you.
Ms. Ferguson. Is Norm over there?
So they'll send us a setting in the mail? or
No, I'm
something?
gonna tell you what your date
Oh,
is right
that'd be
now.
awesome. Where did?
Yeah.
I brought this, Oh, it's right there. It's at my foot.
All right, this is coming back on May 21st for a contested hearing.
We have a later date,
No, that's it. Okay,
May
21st.
1st
21st,
21
yes,
at 9.
yes.
Got it.
All right, thank you. You're welcome. All right, thank you.
Can we get a bond?
Oh, you have to file a motion and then I'll hear it.
Okay, this is his third MTR. Is there any hope?
Oh, yeah, I mean, he's on deferred education. Yeah, he's entitled to a bond.
Oh, okay.
Yeah.
So just file a motion.
File a motion and I'll hear it.
Okay,
And usually they don't object to notice. So
okay,
you can file it, we can put it on the docket for tomorrow. But if you not, wait, tomorrow is Wednesday, correct? Yeah. So we can put it on the docket probably for Thursday, but you'll need to make arrangement with the coordinator to put it
Okay.
on the docket.
all right. Thank you.
Thank you. Do you know what is being asked? Do you know if it would be anywhere in the previous competency evaluations?
I think it needs to be correct, Judge. I think
Okay.
the last comment was at least several months ago, so I think that all we need to do is have someone from UHS help us, but I don't have the least.
Okay.
I know there was someone on the Zoom named Paul, the only person I'm seeing here is Pete Ramos, but it's indicating that he's from CHCS. I thought he said on the Zoom that he worked with UHS.
Hmm.
So I think that might be the assistance of a jail liaison from the center or someone from UHS to get this. I did leave a message with Miss St. Clair. She hasn't gotten back to me because I was asking if anyone in custody has been screened and how we can go about doing that. So I'm still waiting for a callback on that. But we have run into roadblocks trying to get this information from UHS, so.
All right, can I have that printout, please? That's.
I think Paul,
Morning, Judge.
Good morning.
that's
How you
okay.
doing, Stephanie?
I'm doing great. How are you doing? Thank you. All right, so I think we've come up with a plan to help you. And when I say we, I mean probation, your attorney, and all of the medical personnel. So there's a couple of things that your attorney is going to want to go over with you today.
Yeah.
And if you can talk to him about the information they're requesting, his brother may or may not have access to that or may have it. Because I think his brother may be his guardian. I'm not 100% sure. And so he may have that information.
I can check, Judge, and if not, I will contact the jail liaison and maybe UHS since I have this to see what we can do. Hopefully Ms. St. Clair can come back, because I was trying to see if she's ever screened someone in custody. And then we'd also have to check with SB and see if Mr. Payne can be transported directly. If he can't be transported, maybe that needs to be his brother or possibly might be some of the assist, but ideally that's where she's just set up.
Okay. And then I don't know if the jail did any type of assessments.
They took the initial screen, but I think the most current and the one that they would want, because it's asking for daily updates in here, would be UHS, because they're the one giving you medication.
All right.
So maybe with this, I can get some.
Okay. All right. Awesome.
I'll check
this.
Oh, thank you.
You.
Oh, thank you. And you're looking better too. We're going to try to get you out as quickly as possible. Okay. All right. All right. Thank you, sir.
I'll look in the probation file to see what we have, but
Let's go back.
there are certain medical things that I would not be able to release unless I had some type of subpoena or court orders.
Okay. I'll do a court order. I'll do that right now.
Thank you.
And then you'll get the release. So let me do that right now.
Thank you.
All right. Thank you. All right, Mr. Seeloff, are you ready?
Yes, Your Honor, we're ready. He wants to make an announcement to the court, please.
All right, and what's your client's name?
Eric Guzman. He has two charges, possession, by a felon and, a drug case.
All right, yes.
I would like to retain the word.
All right, if you want to hire an attorney, then Ms. Ferguson. Set this in 30 days. Mr. Seeloff, you're still the attorney.
I understand.
Unless he hires one.
I gave him a card of Mr. Young. He is very good. And so hopefully he can, make some arrangements with him.
Right. What date, Ms. Ferguson? June 4th.
June 4th.
Right.
I don't need any further notification, right? I guess.
All right, thank you.
June 4th.
Got it. All right.
Thank you.
You did go back.
All right, court is calling 2020 CR 7507.
This is the critical turning point in the hearing. The judge has already heard that the defendant completed inpatient treatment, yet she repeatedly failed to submit to required drug testing and stopped following the conditions of supervision. From a legal standpoint, these admissions significantly strengthen the state's request to revoke community supervision because the violations have already been acknowledged in open court. Emotionally, you can hear the growing frustration in the judge's questions. The court isn't simply evaluating a missed appointment or a paperwork issue. It's examining whether prior treatment efforts, supervision, and opportunities for rehabilitation have produced meaningful change. Here's a question for
Garza, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure. Violated condition number 2, on or about the 18th day of November 2025 in Bear County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 2, on or about the 9th day of December 2025 in Bear County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure. And finally, violated condition number 2, on or about the 30th day of January 2026 in Dade County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
Sure. State will waive the remaining allegations.
Any objection to the waivers?
No objections.
All right, and that's for number 2s. All right, did you understand by pleading true to violations 2, 2, 2, and 2, the court can find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true?
Yes.
Court will find 2, 2, 2, and 2 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion, enter an adjudication of guilt, revoke, and sentence to 4 years in the prison. The state will also take into consideration clause number 2026 PF 14573.
All right, did she do any inpatient treatment?
She did, Judge.
Okay. All right, so why is she not testing? This is her 3rd MTR. So can somebody explain to me? All right, if you want to explain, you'll have to raise your hand and I'll take you under oath. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. State your name for the record.
Desiree Garza.
Ms. Garza, the judge asked you a question, why you were not submitting to the UAs. Could you answer the judge why you have not submitted to the UAs or why you missed them? What happened in your life, why that happened?
I was going through a lot at the time and I knew I was dirty and I'm not gonna lie, I knew I was dirty. I didn't.
So that still doesn't explain why you didn't report, because you have responsibilities. So you were just not following through on anything. And if you've been in inpatient treatment, they've talked to you about what you need to do in order to stay clean and sober. You just choose not to do that. So I don't know why I should give you 4 years and why it shouldn't be more. So does anybody have an answer for me?
Judge, I understand the court's position. She has been a safety. There's been some expense that the state has put out there for her rehab. Obviously, addiction is a difficult thing people deal with, and it's something she has dealt with. One of the recommendations in the probation officer's file was revocation of course, as well as safety special needs. I guess that's a separate safety program from what she's done before. I've explained to her, judge, that on a revocation, she's going to be repeated from here on out. She'll have a PDC trip. She's not over probation if she ever gets in trouble again. She just assured me that she has a daughter that started in the military, is about to graduate. This boot camp, I'm assuming. She wants to try and put this behind her. Obviously, her track record is not really showing that she's capable of doing that as of yet. We understand that, judge. We're asking the court to consider even the 4 years TDC. There's a lot of bite to that because she will be a convicted felon now. She understands that. So she'll try and put this behind her as quick as she can and move forward in a positive direction.
And is this her first felony? And the reason why I asked that, because the plea bargaining agreement, the state was silent on your application. And so the court gave you deferred adjudication. And at that time, they were asking that you be sentenced to 2 years in the prison.
Based on looking at the history, Judge, I do not see any, there's not county convictions. I do see, however, there have been several arrests that have been.
All right, this is what the court is going to do. The court is going to grant the motion, find you guilty, revoke, sentence you to 5 years in the prison. Give you credit for any time served. There's to be no unsupervised contact with minors, no residing in households with minors, therapeutic community. And I will give you credit for any successful inpatient treatment completion.
Thank you, Judge.
All right, did you? Yes.
She has a monitor on her ankle as well still. I think the court ordered it from what she shared with me. It's RMS
They
monitor.
got her they have her with a monitor and while she's at the jail?
Yes, and I've never encountered that before, Judge, but the deputies told me that it happens more often than you thought. I thought I could just call pretrial GPS and have them come remove because maybe they didn't need the monitor for someone else yet. But she's sharing with me that is actually through, which I think is something you might have ordered on her last MTR.
Okay,
You had ordered it when I got released from St. Pete, like relapse.
all right.
Yes.
Ms. Abrams, did we order a monitor for her?
Judge,
Are they letting you charge the monitor at the jail? All right,
it was partially done, at her last.
all right. I'll order removal of the monitor.
Thank you, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you will need to speak to an attorney. Do you understand?
Yes.
And also, you all are taking something in consideration, correct?
Yes, sir, I emailed the intake.
All right, so, and also for the record, taking in consideration 2026 PF 14573. All right, we can go off the record. Here's the thing. If you don't change your life, you know what's going to end up happening? You're going to end up going back and forth to prison, or you may end up somebody identifying your body, because you never know what you're going to get when you're taking drugs.
Yes, ma'am.
When you're released from, take advantage of the therapeutic community. The therapeutic community doesn't increase the time you're in custody, but it's designed to help you. So what will end up happening, I've ordered it. They're going to see it on the judgment, but I don't have jurisdiction to force you into that program. So you're going to have to ask for it as well. When you're released from prison, the first thing you need to do, go to Lifetime Recovery, go to felony drug court. And this is why I'm suggesting you go to felony drug court. Felony drug court will have all the resources for you to get you in an inpatient treatment facility. Do you understand?
Yes.
All right. I don't want to read about you on the news. Okay. All right. Good luck to you.
Maybe excuse Judge.
Yes. Who's next?
Okay,
So where are we on contracts and all of that?
Contract has been submitted today, Your Honor.
Okay. Norm, I need a final PTD date. June 4th. All right, June 4th. Thank you for dressing appropriately for court. Once you sign the reset form, you will be excused. All right, thank you.
Thank you, Your Honor. May we be excused?
Yes.
you have a pizza.
Yes.
This dismissal needs to be done from yesterday.
All right, thank you.
Thank you.
Working on one more people.
All right, thank you. All right, who's here on Stephen Lamone? All right, thank you. Probation, this is an application. Hello. All right, court is calling 2026 CR 003283 State versus Stephen Lamone. Can I have parties announced?
Rene Munoz on behalf of Mr. Limon.
And are you Mr. Lamone?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Mr. Lamone, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented? Court will find that the state is in compliance with discovery. Mr. Lamone, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with driving while intoxicated, third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That is correct.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Lamone, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $0 fine. The state is recommending community supervision. This is running concurrent with 2025 CR 007431. Restitution, if any, and 2-year driver license suspension or affidavit of non-driving. Did you understand that to be your plea?
Yes, Your Honor.
Defense state?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Any such motions?
Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours of community service restitution, 10 days in the Bear County Jail, participation in the felony drug court, DWI intervention, VIP live, and ignition interlock for half the term. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
To the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, and most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
And I'm assuming he's already been accepted into felony drug court?
He has, judge, in that case that is to run concurrent is also a case that he's currently on.
All right. So here's the thing. And I know I probably told this to you before when you were placed on probation. You can't drink alcohol, period. And if you continue the way you are, one, you're going to end up destroying your liver. And then you're going to be on some site asking for somebody to donate a liver. You're going to destroy your kidneys, or you may end up killing someone. You understand? And I understand that you have military service, but any issues that you have that's related to that, you're going to have to start addressing those and not through alcohol, because otherwise it's not going to end well. You understand?
Yes, sir.
All right. This is what the court will do. The court is going to sentence you, as previously stated, the court, I'll state you may be excused. As previously stated, the court is going to find you guilty. The court is going to sentence you to 8 years in the prison, suspended and probated for 5 years. There's to be regular random UAs, regular reporting by Zoom or in person, proof of employment within 45 days of release, no employment as a home health care provider or with minors. He's to remain in custody counsel until released by felony drug court.
Yes, Your Honor.
There's to be a 2-year license suspension. This is to run concurrent with 2025 CR 007431. 200 hours of community service restitution. I'm going to deduct an hour for every sober support meeting that's completed. Field visits 1 time per month until further notice. DWI intervention, DWI education, VIP live, restitution, if any, to Paul Sparks. Ms. Ferguson, I need a restitution date. State, how long will it take to get restitution?
But 2 weeks is fine.
All right, can you set it 3 weeks? All right, that'll be May 26th for the restitution hearing. And I assume they said in here that they would allow an affidavit of non-driving, but what I'm gonna tell you, if you have access to any vehicles, like it's in your parking lot, I don't care if it's somebody you're living with and it's their vehicle, then for the court, you have access to that vehicle and that vehicle will need ignition interlock. You understand? All right, so
Your Honor, one quick question regarding the restitution hearing. If he is in an inpatient facility, can he appear through Zoom?
yes. So that's ignition interlock, full term, or affidavit of non-driving with proof of no access to vehicles. And probation, I know it's hard for people to prove a negative, but once you all go to the home, you'll be able to see if he has access to vehicles. So it's ignition interlock full term or affidavit of non-driving with proof of no access to vehicles. And that will be with a portable alcohol monitoring device. 10 days in the Bexar County Jail as a condition of probation. Probation, is there anything else? Is there anything else you need from the court to be successful? You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so here's the thing. You got to figure out why you're using, and you've got to figure out what works for you to maintain your sobriety. And if there are people who are around you who realize that you shouldn't be drinking, and they tell you, oh, it's just one drink, those are not your friends, and you're gonna have to cut them off. Your sobriety needs to be your number one priority, okay? All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome.
We had a plea paperwork ready to go. He wouldn't swear to it. He wants to hire an attorney now.
All right, Ms. Ferguson, set this in 20 days for a jury trial.
Yes, sir.
You need to let that attorney know that they need to be ready for trial. All right, your jury trial date is going to be May 26th. Once you sign the reset form, you're excused.
You're
You're
gonna
welcome.
hire one, yeah?
All right, who's next?
I have. We can have a pizza. Please. This is on page 4, first one.
All right, Kit Kilpatrick. Good morning. One second, obviously it's a little slow. All right, court is calling 2026 CR 0022796 State versus Kit Kilpatrick. Can I have parties announced for the record?
Jonathan Alvarado for the defense.
And are you Ms. Kilpatrick?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
All right, did you review the application for community supervision and deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, sir.
Court will find that the state is in compliance with discovery. Ms. Kilpatrick, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
I did.
Did you understand if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Judge.
Ms. Kilpatrick, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, no.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication. They're recommending community supervision. This is to run concurrent with DC 25-9847 out of Gillespie County. Did you understand that to be your plea?
Yes, Your Honor.
Defense and state?
It is, Judge, yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 hours community service restitution, MRT, and DOEP. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I do, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I do, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Okay, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes,
The
Judge.
court has now reached its decision. After reviewing the violations, listening to the defendant's explanation, and considering both the state's recommendation and the defense's arguments, Judge Boyd granted the motion, adjudicated guilt, and imposed a 5-year prison sentence. The ruling reflects the court's conclusion that repeated failures to comply with supervision conditions outweighed the opportunities that had already been provided through treatment and deferred adjudication. At the same time, the judge's final remarks reveal an important theme often seen in these cases. Accountability and rehabilitation are not opposing concepts. Even after sentencing, the court encouraged the defendant to pursue treatment, avoid future substance abuse, and take advantage of available recovery resources. The outcome serves as a reminder that second chances come with responsibilities, and repeated violations can eventually lead to serious consequences. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.